Welcome to another edition of the Global Antitrust Institute's Conversation Series. I'm Bruce Kobayashi. I'm professor of law at Scalia Law School, and I'm actually the founding director of the GAI. I actually started it with Doug Ginsburg in 2014. Today's topic is non-compete and no-poach agreements, and we are really fortunate to have as our guest Evan Starr, professor of management and organization at the University of Maryland, Robert H. Smith School of Business. How you doing, Evan?
I'm doing okay, Bruce. Thanks for having me.
It's great. There really is a lot of interest in the antitrust community and at the agencies in labor market monopsony issues generally, and in particular, no-poach agreements between employers and non-competition agreements between firms and their workers. I would say they're sort of kissing cousins in both sort of the good and bad stories. But certainly no-poach agreements were the focus of the 2010 DOJ action that turned into a high-profile 2013 class action involving a lot of the big Silicon Valley law firms. The expert in that case for the plaintiffs was my econometrics professor at Leamer. I think Kevin Murphy from Chicago and CRA was on the other side. So it was a really sort of an interesting case. No poach agreements contained in McDonald's franchise or franchisee agreements are now the subject of a large class action, Turner versus McDonald's USA LLC, that's in the Northern District of Illinois in federal court, and has survived the motion to dismiss. Other franchisors and businesses are facing similar suits. In 2016, both agencies issued joint statement on no poach agreements. The DOJ has recently announced and reiterated its intent to go forward with criminal prosecution of no poach agreements. There's certainly a lot of interest on that end. Non-competition agreements have also, in their own right, generated a lot of interest at the agencies. Perhaps the most direct form of interest was the petition filed by the Open Markets Institute at the FTC for a rulemaking to prohibit worker non-compete clauses. There is also, when I was there, a lot of interest from Congress and state AGs. And the FTC held a session, which I think Evan was one of the speakers at during our hearings on competition and consumer protection in the 21st century. So it's really great to have Evan here. I think it's fair to say that Evan is or maybe the leading expert on the empirical effects of non-competes. Even in his sort of still young career, he has authored, I think, over a dozen empirical studies on the effects of non-competition agreements, state policies restricting their use, and enforcement by state courts. So welcome, Evan. So everybody knows, that guy in high school who said, I want to be an NBA superstar player. That would be LeBron James. And it came true. But, more generally, like there are those guys who I'm going to be a doctor, I'm going to be a brain surgeon. And lo and behold, way down the road, they are. That's their career. I'm assuming that's not your story. You're in high school, you weren't saying, I'm going to be an economist, and I'm going to specialize in empirical measurement of the effects on wage and mobility of non-compete effects. So how did you get interested in this area?
Well, first, I wanted to be a race car driver, and it didn't work out.
But you still got time.
That's true. That's true. So my interest in non-competes came out of an inquiry in graduate school, where I was interested in how managers deal with the issue of customer loyalty to employees and how that affected who they allocate clients to and how they manage that process, since they clearly can't control directly where customers go. And so I presented a very bad model trying to understand this phenomenon at an IO seminar at Michigan. And Francine LaFontaine called me up afterwards, and she said, Evan, one way that managers deal with this is they use non-compete agreements. And you should go talk to Norman Bishara, who is a lawyer in the business school at Michigan, who was doing some ethics work on non-compete agreements. And he pointed me to this literature on non-competes. And I as I was reading it, I was just blown away by the debates that were happening primarily in the legal literature some were calling non-competes modern day slavery. And others were saying, that workers would never be harmed by them because they would obviously receive some sort of compensating differential. Some were saying these are absolutely necessary for firms to invest in trade secrets and other valuable information that would otherwise leak out to competitors. And then others were saying that California's ban on non-competes in 1872 was the reason for the rise of Silicon Valley. And so there was these like dramatically divergent perspectives over the last 40 or 50 years, and even longer actually. The first non-compete case was in 1414, so this has been debated over 600 years. And when I would turn to the empirical evidence, I was just shocked that there was hardly any empirical evidence. Matt Marks had done some studies of inventors. Mark Garmay had a study of CEOs, but we had no sense about how common non-competes were and which of these arguments were right. And so that was sort of my research agenda as I was finishing up graduate school.
Yeah, so it's interesting. The first time I've ever saw something written by you or as a co-author was I invited J.J. Prescott to give a seminar at the Rubinstein Law and Economics workshop. I love J.J.'s work, and in particular, given my interest, I was interested on some really interesting work he had with Catherine Spire at Harvard on partial settlements. And so I invited him, and that how that goes. By the time JJ came, 6 months later, he's like, it's going to get published or whatever. And he said, I'm going to give a survey on non-competes. And I said, no, like, how boring. And I just recall that I really thought that it was a great workshop. And my metrics for a great workshop is one, I learned something that I didn't know. And that certainly was true. And it was way more interesting than I expected. But that survey, I mean, it really was the messages I got, and they're very, very stark and simple, is that it was a tale of two worlds. And maybe this is an overstatement, high and low wage, right? The high wage guys seem to know about what they're doing, and they seem to at least get some benefits. And then there were the low wage guys who didn't know they were actually signing them and didn't seem to get any benefits. And JJ put up the non-compete for the picker at Amazon. And everybody just sort of laughed and just said, what is that? Why would they do that? So, I mean, talk about that survey. I mean, it was a big deal. It got picked up by the Council of Economic Advisors, and everybody said, oh yeah, did you see the CEA report? And I said, no, you really mean, Prescott's Starr and Bashara. But why don't you talk about that? Because I mean, a survey, it had to be a lot of work, but talk about why you engage in that work.
Yeah, I mean, I was proposing defending my dissertation proposal, and JJ and Norm were on my committee. And I remember out of reading this literature, I thought, what we need more evidence. We just need more information. And there were several studies of state policies that I was working on, but I thought we just can't know that much more until we actually gather evidence. And so I proposed to collect a survey, and with the blessing of my committee, they approved it, and Norm and JJ helped me fundraise to gather data. And I did a whole bunch of research on how to write surveys. And one of my advisors was Charlie Brown, who was the director of the panel study of income dynamics, which is one of the longest running panel surveys in the US. And so I had great guidance, and I learned a ton about how to write surveys. And I mean, coming out of graduate school, I couldn't have believed that folks would have picked it up in the way that they did. And it was really fortunate to be the one who had data when all of this stuff kind of hit the fan. And so, that the whole survey was designed to study who signs non-competes, how they matter for workers. And at the same time, there are some severe limitations, which is that it's a cross-sectional survey. It's really difficult to identify the effects of non-competes in such a setting. And so we have a few little tricks in there that we ran a little information experiment within the survey. But in general, the results are largely descriptive. And I think that's really what people picked up on is, wow, these things are really common. And so that was really where I think the public interest was like, wow, we can't believe that maybe these anecdotes of Jimmy John's workers signing non-competes or Amazon Packers, that maybe this is more common than we thought. And I think that's really where a lot of the impact was initially.
Yeah. Now, so you've obviously stuck with non-competes. I'm a guy who does a lot, puts their fingers in a lot of pies and spreads it around. And you're sort of have a nice research agenda is because you've covered a lot of sort of different problems in this area. So I mean, with the such interest in sort of the low wage worker thing, because I teach IP to the law students, and you go in your trade secrets section, and it's a natural story that, yeah, like the guy, you've given him all the business secrets, and then I mean, all of the famous trade secret cases are the cases of departing workers who start a firm in competition. And so that's the way I always thought of it, is that, yeah, these are something that it's way more enforceable than a non-disclosure agreement. Or but then when JJ put up that Amazon non-compete on the board, I was just, why? And so you did a study on Oregon,
Hmm.
which was a standard diff and diff event study. So
Yeah.
tell us what you found there.
Yeah. To kind of bring it to recent times, there's a large debate, as you were talking about, Bruce, about what we should do with non-competes. And one of the largest thrusts of that debate is maybe we shouldn't have these for low wage workers. What's the point of them? Maybe the engineers make sense, maybe the managers, but why are they being used among low wage workers? And actually, one of the results from the survey data that was the most surprising to me was that we find that non-competes are actually among those who sign non-competes, hourly paid workers make up the majority of non-compete signers, about 53%. And that's because they make up such a large part of the labor force. And so the modal non-compete signer is not some highly paid executive; it's an hourly paid worker. So I think that the policy interest has been in what's the role of these for low wage workers, and our theoretical interest was twofold. First, that it's possible that these are good things for low wage workers. If you go back to the history of non-competes, they arose in the guild era where master craftsmen would train apprentices for several years. And then they didn't want those apprentices to go use that training in the same product market. And so it's possible that non-competes are good for low wage workers because they give firms incentive to train them, provide them with skills which will benefit them in the future. And on the other hand, you have some arguments that suggest that low wage workers may not be careful readers of their employment contracts. They may not have the financial resources to access the legal system. Their non-competes may not be unenforceable, but they may not be able to fight to get out of them. They may have low bargaining power ex ante. So all of these issues suggest maybe that non-competes are going to be bad for low wage workers. And so ex ante, we really didn't know what to expect. And then there's a third argument, which is that who cares about low wage workers? They could go to any other industry. You're making $12 an hour at Amazon, go make $12 an hour at Wendy's, or whatever it is. So who cares? And so I think that's kind of the baseline where we went into the study, and what we found was that in 2008, Oregon was sort of the first state to ban non-competes for low wage workers, which is a policy that has been passed now in several states in the last few years. And after 2008, what you see is that hourly wages in Oregon start rising up to about 6% higher than control states out of 5 years later. We also find that within industry, mobility rises about 17% following the ban, again among hourly paid workers. And so I think that the results did suggest to us that the arguments that non-competes or enforcing non-competes is going to be beneficial to low wage workers or it won't harm them at all appeared to be inaccurate.
No, that's interesting. I mean, one of the states that just recently enacted a ban on low wage worker non-competes was your I guess adopted state.
Yeah.
You grew up in California like me, right? Actually, in the
That's right.
Negro Valley. Um,
Is that right? Yeah. We're
yeah,
from the same area.
Montebello. Yeah. So,
Okay. I'm from Claremont.
but
Yeah.
did you are you planning a follow up on sort of Massachusetts? I mean, one of the things that when I was at the FTC, we had a staffer do a survey, and one of the things that he noted with '08 was it was '08, and there were a lot of stuff going on, and
Yeah. Yeah.
it,
Terrible timing. Terrible timing.
yeah, terrible timing. You can't get that that identification because there's all kinds of stuff going on. But
Yeah.
Maryland and Massachusetts, and I think there's one other. Are you planning to do a follow-up, or is that just too obvious?
Yeah.
Um,
I know. I mean, honestly, what I've been working on. So, absolutely, I think a follow-up should be done. I see the Oregon study as kind of initial evidence that maybe we should be concerned about this for low-wage workers, and it certainly bolsters the policy case. I'm not sure we can say it proves it, but I think that absolutely, with the variation that has been created by these policy changes in the last few years, it's absolutely a time to study those. And in some sense, I'm waiting for time to pass. But in the meanwhile, I've been trying to collect more data on who signs these things so that we could actually have a more careful study. Because one of the limitations of that Oregon work is we don't know who in the data has signed these and who hasn't signed them. And so one of the things I'm most excited about is that in 2017, I was able to work with the Bureau of Labor Statistics to add a question on non-competes to the National Longitudinal Survey of Youth in 1997. And so that the data from the first wave just came out in December 2019. And my understanding is they're going to keep asking that question for years to come. And so hopefully you could combine that evidence, that data, with these policy changes to have some powerful evidence.
yeah, I mean, that Maryland must be a great place. John Haltiwanger was actually a UCLA professor when I was there, and I know he's really a great resource there.
Yeah, it is. It's a great, really supportive environment.
So the one thing is that you focus on mobility and wages. And of course, GAI, the A is an antitrust. Uh, we're an antitrust body, so
Hmm.
I have to ask you about pass through and monopsony, right? Because the one
Yeah,
thing that I mean, it is, even if you don't sort of bring in the antitrust aspects, it is an interesting issue. The question and I think there's a paper by Nancy Rose and Scott Hemphill, which is really interesting in the Yale Law Journal. And they said, it should be an antitrust violation if there's harm to trading partners. And we were all thinking, well, what if Walmart bargains really well and negotiates a lower price for Tide from Procter and Gamble, or whoever makes Tide, and then that's passed through to consumers. If you sort of look at that market and not worry about the general equilibrium stuff,
yeah,
that's going to increase welfare, and we're happy with that. And so the question here is, if wages fall, it's a problem if it's monopsony, right? If you're looking at the marginal factor cost and not the supply curve, then that causes the same kind of output effects as monopoly. And so it is an antitrust problem. Have you thought any about sort of the general monopsony issues and sort of
yeah,
maybe measuring output effects or something besides sort of, I mean, workers are a set of people. I mean, I work, you work.
yeah,
Now
yeah,
we have
yeah,
academic jobs, and we probably don't work that hard. I'm just kidding.
yeah,
But
yeah.
obviously, from an antitrust perspective, you are concerned about whether or not this is an efficiency or it is monopsony. I think that's sort of the
Absolutely.
difference.
Absolutely. I mean, I see the connections in that when you use non-competes, there's many anti-competitive reasons you could use them. I mean, they do exert. I mean, they're restraints of trade in both the labor market and the product market, right? So they do give the firm labor market power over the worker in the future. If that worker gets a job offer, they might not raise the worker's wages. They could also under resource the worker or do other things. And if the worker's stuck there, they'll have to take it. On the product market side, non-competes they also prohibit workers from departing and entering and competing with their prior employer. And so they are directly restraints of trade in the product market because they prevent competition from potential competitors. And I think that matters all the more when an industry has a really high use of non-compete agreements. I think your point is well taken. There are efficiency rationales as well, like we've talked about with spurring investments and trade secrets, et cetera. To get to your question about prices, right? So wages are one price that we care about, and as a labor economist, which was my primary training, it was just drilled into us that wages equal marginal product, and so I think that like showing that wages change when these laws change, when the underlying productivity of workers is likely constant, is suggestive that's not true, and that's kind of building on a larger body of evidence that firms do have labor market power generally, and that these policies and contracts tend to exacerbate that power. Getting to the question of how this then passes through to consumers is a really important question. And I think that there's two avenues. If you want to talk about prices, there's only two papers I'm aware of that have estimated these pass through, and both of them suggest that the use of non-competes inflates prices. And that's a paper by Kurt Levetti and Naomi Hausman looking at healthcare prices, and then a paper by Gurun et al. In the financial services industry. And in both of those studies find, relatively large pass-through effects. Just to cite the headline result from the Gurun paper, they're exploiting firm entry into this broker protocol, where basically there's a group of firms that won't sue departing advisors. And what they find is that for firms that then enter that protocol, that prices for their clients rise about 14%. And so I think there are concerns about rising prices. I've seen less on the quantity side, on the output tests of monopsony and monopoly, but certainly there appears to be some evidence, growing evidence, that the costs of these mobility constraints are passed on to consumers.
And the Gurun et al. Paper, they presented that at the BE Micro Conference. It was very interesting because they did sort of, that's, I think, the type of work that would be really useful, just to say, because we tend to sort of look at the product market in antitrust. Here was an example of where you could see sort of the downstream sort of effects. And I haven't kept track. I thought it was a great paper. Just not necessarily, going through the methodology and all that stuff, but just sort of the conceptually that, what we want to, you have a lot of things in antitrust where you have platforms and you have arguments of where, do you think about all markets at the same time or a vertical merger? And most of the economists you talk to said, yeah, you think about everything, as much as you can. And I thought that along those lines, that paper sort of.
Yeah. I think the maybe most interesting, I think some caveats on that paper. Some of the estimates are just incredibly large.
Yeah.
Almost implausibly large. Like, it would be nice to see some corroborating evidence, but
yeah. I always think that if people ask what book should you read, I think it's Angrist and Plishke's most econometrics, and I'm talking about in grade school or something. But yeah, nothing's perfect. You can't.
But I think the other part about that paper that is interesting is that we see pass through in terms of higher prices, but we also see firms who are when non-competes are not enforceable and not used in this context, when firms enter that protocol, that firms are more likely to overlook misconduct. Because they want to keep the book of business at their firm. So there, I think that cuts the other way, and it pushes in the same direction. Excuse me. So it's interesting. These various effects.
And I think that one of the things when you want to move out of labor and into antitrust, that's certainly one of the things that you have to think about. I want to spend just a little time on enforceability, notice, and consideration. The interesting thing about having the job of director of the Bureau of Economics is that you have to not only think about antitrust but consumer protection, and this would be sort of more consumer protection like. But how important is that? That was one of the things in sort of the survey when JJ presented it. Is he said, look, one of the things is these people don't even know they're signing these things. One of the and you have sort of the consider this, and you said, look, there's some states which basically won't enforce non-competes unless there's some form of consideration. So you have to get training, you have to get a wage, and it seems like things are not horrible even for low-wage workers in those states. There's at least some compensating differential. How important? And I guess when you do sort of policy, that's one of the things that you say is that there should be some kind of consumer protection notice. How far would you think that gets us in terms of?
Well, I think it's tricky. So I think if you go back to the economic theory, if we had sort of a full transparency situation, you would hope that workers wouldn't agree to restrictions on their future well-being unless they were compensated ex ante in some way, shape, or form. And so, it's not clear. One could argue that based on theory alone, that we don't need any sort of policies guaranteeing consideration because the markets will take care of this. And then I think when you get into some of the reality, some of the data suggests that workers negotiate non-competes only 10% of the time. 86% of them say they were not explicitly promised anything for agreeing to a non-compete. A third of non-competes are implemented after the worker has joined the firm already, so without any change in responsibilities or other terms of the contract. And so it runs into some tricky issues. And so some states do have policies that say, yeah, we need to require upfront consideration in order to agree to a non-compete. And I think that the policy, and there's some evidence that suggests that those policies, there's my paper and there's a recent paper by Kurt Levetti, Matt Johnson, and Mike Lipsitz, which finds the same thing, that it's those policies which appear to be driving the wage effects. But I think from a policy standpoint, it's really tricky. How do you ensure that workers are compensated the right amount? Is it $100 bonus on the signing day? Is it, some promise? I know the Oregon law says it has to be a bona fide advancement, but like, what does that mean? Is that a promotion? Is that it's really tricky. And so, one approach that some folks are taking recently is to think about garden leave. And garden leave is a policy that's apparently popular in Europe. And garden leave pushes the consideration to the back end. It says, we're not going to compensate you up front necessarily, but we are going to pay you some fraction of your salary during the prohibition period. So if you have a non-compete that's 2 years you can't compete, then the firm has to pay you 50% of your salary for those 2 years. And that would be the consideration that you get for signing that contract. And I think the one thing that I like about that is that it could deter firms from using these sorts of low-wage non-competes up front that appear to be purely anti-competitive, because it shifts the cost to the employer. Of course, you still have to enforce that. And if firms may be loath to pay that, but that's one upside. The downside is, of course, that now you've got idle workers sitting out of the workforce for maybe 2 years when they could be productive. And so there is certainly a tension, and it's not obvious what the right policy solution is here. But there is, I think, my work and several others have now shown that there should be concern about workers benefiting from these contracts. And it appears that most of the evidence suggests that they're harmed.
There was I was reading Tyler Cowen's blog, which
Hmm.
I don't read that many blogs, but I really like his. And he had a blog about Schubert, Stansbury, and Tasca. I don't know if
Oh,
you
I
know
know that
that.
paper. Yeah, yeah.
Yeah, about
I
outside
didn't see his
options.
post.
And I was thinking, the Amazon thing would affect both sort of, the standard within industry. And I always worry about the measurement of, labor concentration. But setting those aside, they make, I think the real sensible point is that the bargaining and the monopsony power will depend on your outside option too. And
Yes.
has anybody done work on sort of the extent and scope of the non-compete and the effects?
Yeah. So I think uh, the paper by Stansbury, Schubert, and Tasca is a great example, and there's another paper by Oren Danieli and Sidney Caldwell, which is sort of similar, making the point about the value of outside options and what is the relevant labor market, and how large actually is it. And I think that literature has generally not considered uh, not non-compete agreements in the following sense. You might have a labor market which appears to be relatively competitive,
Right.
but once you account for the fact that most workers in that market are bound by non-competes, that's going to knock out all of the within industry options. And if those within industry options make up the bulk of that supposed labor market, then the market is actually effectively much more concentrated than it appears without taking into account of non-compete agreements. So I think
Yeah.
I think the literature has not yet grappled with those distinctions.
Your next paper, right?
Yeah,
Uh,
yeah.
it is interesting because, as you say, they sort of, the interesting thing is they said, look, there's this sort of, labor market concentration part, which, I think, Marshall Steinbaum and others have sort of looked at. And then there's this sort of outside options thing, which also controls, how much of the bargaining rights you get when you bargain with your employer, or the equilibrium amount.
Yeah.
And the non-competes will, as long as it's overbroad. So let's set aside the Amazon thing. The non-competes
Okay.
will affect the first one, right? It'll
Hmm.
affect sort of the relationship between labor market concentration and the wages. if there
Yeah.
is such a, and would leave sort of the outside option or make it more important. And I think one of the things they want to stress is that outside options are also a constraint. I mean, you're an academic. You
Yeah.
moved, right? You're not at your
Absolutely.
first job.
Yeah.
And
Yeah. I've
yeah,
moved.
I mean, that's really how you get a better deal at
Exactly.
any place. You have an outside
Exactly.
option. So,
I mean,
so
I think that this goes to the point of how do you measure labor or labor market concentration? Should it be in levels of employment or in vacancies?
yeah, yeah.
Because it doesn't matter if your industry employs a million people if there's no openings for you to take, because then you have no
Now,
actual outside option.
it was I mean, I did get a headache, but I have lots of time on my hands. And yeah, it was an interesting paper, especially the way they measured sort of the relevance of whether something is a actual or useful outside constraint. They sort of have
Yeah,
this discrete choice thing. All right, I want to basically we're probably over, but
it's okay.
I want to spend some time on high tech. Um, so,
Yeah,
as I said at the start, when the survey said, there seems to be, at least to some extent, a tale of two worlds. I think your
yeah,
further research would say that's not true, but the survey said, if you poll high tech workers, they're happier. They know about them when they sign them, and they pull and they get some wage bumps. So, what do you say with respect to high tech workers? Should we just leave that alone, or is there some type of results that even apply to that setting?
yeah, yeah. So just to quickly address your characterization there, I think that the two stories that emerge from the survey evidence really relate to. Well, there's a question about who signs them, and certainly tech workers are much more likely bound by them. About half of tech workers, by one estimate, sign them. um, the survey evidence suggests really that the key is the transparency that it didn't have anything to do with occupations. We didn't have a cut in there of the effects of non-competes by high tech or low tech. It was really about when do you have a chance to agree to the non-compete before you accept the job or after you've already accepted the job. And that was the two stories that kind of diverged. If you get it beforehand, you appear to be better off. After, you're worse off. I think that to come back to your point about tech workers, though, I think tech is a place where we would have expected to see the benefits of non-compete agreements, both for workers and in product markets. And I think I highlighted at the beginning that there's some anecdotal evidence about Silicon Valley. Of course, California's was hasn't enforced non-compete since 1872, and some claim that's caused the rise, although that account is disputed for several reasons. So one of the things I wanted to look at was I was looking for exogenous variation where we've adopted a full ban, where this is a pretty rare policy event. Usually the policymakers are kind of tinkering around the edges. We were looking for a full ban, and so in 2015 we learned that Hawaii banned non-competes only for tech workers, where they sort of ignored low wage and other students and other sorts of issues that other states are now addressing. And so this presents kind of a unique policy experiment where you can compare tech workers in Hawaii to other workers in Hawaii. You can compare tech workers in Hawaii to tech workers in other states, and you can combine both of those various dimensions in a triple difference specification. And so what we did, we looked at that, and we saw that basically after Hawaii bans non-competes for tech workers, we see the same patterns in the low wage study. We see that job separations increase about 11%. We see that the wages of new hires rises about 4%. And so it suggested that some of the same elements were at play, and we supplemented that analysis with a less well identified study using uh, longitudinal employer-employee match data in the U.S. And I think this is for me, this is sort of the punchline. One of the issues that comes up is the workers may, if there are investments in workers that are really valuable, that may not appear in workers' earnings today. It might appear tomorrow or the next day or 5 years from now or 8 years from now. And so what we do in that study is we compare workers, high-tech workers in who start their careers in states that don't enforce non-competes, and we compare them to workers who start their careers in states that vigorously enforce them. And we have a control group that kind of nets out the differences in the states. And what we find is, and we followed them after 8 years, and we find that after 8 years, those who started in the high enforcing states are 8% less mobile. They have 8% fewer employers over that time period, and their cumulative earnings over that time period are 5% lower. And so we're seeing the same pattern that we saw before. And so it doesn't really suggest that workers are benefiting, even high tech workers. are benefiting from these things. Now, of course, the firms may be training workers more. There could be other investments that are happening, but the workers don't seem to be getting those benefits.
And I have to, because we have to like not have false advertisement. We have to talk about no poach agreements, although it's not
Oh,
really
good. Yeah.
something that is in your wheelhouse there. I mean, I always
Sure.
thought,
Yeah.
I mean, a long time ago, I was thinking about sort of the high tech worker antitrust litigation in California, and I said, well, of course that they were not doing it was non-solicitation agreements because they can't enforce non-compete. So I thought that I say kissing cousins, but they're substitutes.
Yeah.
From an antitrust perspective, they are horizontal agreements between firms that now, as announced by the DOJ, are going to be subject to criminal enforcement. So obviously they treat them much differently. I mean, maybe do you have sort of a 20-second view of sort of the relationship between no poach and non-competes and whether
Yeah.
or not that's the right approach to
I don't
treat,
know. I don't.
treat them
I don't know if I can.
differently or treat them the same or
I don't know if I can hit 20 seconds, but I mean,
uh,
my sense of the differences are that non-competes are employment agreements that workers have to assent to them, and they've traditionally been under the purview of states. And whereas no poach agreements are invisible to workers, they operate above their heads. They're agreements made by management of two companies. Um, and so no poach agreements also tend to be bilateral. It's two companies that agree to them, whereas a non-compete agreement extends to the whole industry, typically to the whole industry or within geographic and time boundaries. So there are these kind of distinctions between them, but I think the fact that the workers don't assent to them, that their mobility options are being restricted by their managers' choices, I think that's the crucial difference that underlies their differential treatment under the law.
okay. Well, I could go on for a lot longer, but this will probably crash the GAI server if we do. So I
Wait,
want
Bruce, I think I want to say one thing. I think I misspoke about the direction of the effects of the Gurun et al. Paper. I
yeah,
think it was
Guru,
that it
yeah,
was
yeah,
entering it was that entering the protocol caused prices to rise, which means that
right.
it was that unenforceable non-competes well, caused prices to rise. The
Yeah,
opposite of what the Levetti
yeah,
study found. So
yeah, it
forgive
seemed
me
to
for
raise
mixing that
costs.
up.
Right.
Yes,
Yeah, no, it's an interesting paper.
yes, yes,
Whatever the
exactly.
result, the pass-through effect was that
Forgive me for that.
non-competes were no longer. I mean, it was weird. It wasn't really non-competes. It was just that they decided the protocol was. I mean, there was just too much litigation, right? They
Yeah,
said,
exactly,
you know,
exactly.
some guy leaves, he takes the client. Did the clients follow him, or did he take them?
Right.
I mean, anybody who's a consultant knows that
Yep. Yep.
you're really careful. You try to do a clean room thing, and sometimes
Yeah.
your client follows you, and then there's litigation. And what they didn't want was, let's just stop it. I mean, every time somebody moves, clients go with them, and there's a
Yep.
lawsuit, and it's just too resource intensive. And
Yep.
I think, I mean, the important thing about the Garoon study is that it really does think about sort of the downstream effects of
Yeah.
these things. And
I
I
agree.
really think if you want to sort of hook up non-competes and antitrust, you have to think about those questions.
I
uh,
agree. I
Otherwise, let's
100%
just do
agree.
the minimum wage. Let's make the minimum wage $500 an
Yeah.
hour.
Yeah.
Well, I really sort of going to conclude, but any other work by others in this area that you think people should pay attention to, and then what's next for you? And then thank you.
Well, so I think that all this work being done on labor market concentration and the influence of that on wages and labor market outcomes, I think is really emerging and growing so rapidly. I think that there's also a growing interest in no poach agreements. Matt Gibson has a great paper on Silicon Valley, and if I could just cite his overall finding, a punchline is that just one of these bilateral agreements in the Silicon Valley case was associated with a 4% reduction in wages. And so, I mean, to me, that says just taking one other employer out of the labor market can have pretty large negative wage effects, and I think that's pretty astounding. And of course, it's not a random employer, right? So that's sort of the key issue. In terms of what I'm working on, I've got some new data. I'm looking into trying to understand the whole employment contract in the sense that we've been focusing on non-competes, which are the tip of the iceberg because they're so restrictive to tell workers they can't go work in their chosen industry. Just But there's many other restrictions that firms regularly deploy alongside non-competes. So one headline finding is that if you're bound by a non-compete, you're almost certainly going to have a non-disclosure agreement, a non-solicitation agreement of clients, and a non-solicitation agreement of coworkers. And so these things come as a bundle, and we don't have much of an understanding of how that bundle shifts, how it changes, how the whole bundle matters more than just a provision. And so I'm going there and doing some field experiments with non-competes to address some of the lingering causality issues, and we've got some new data on non-competes from Japan that I've been looking forward to working with.
Well, I will follow through on my promise to have you out to Scalia, hopefully in person, not on on Zoom
Yeah,
or whatever. But thank you for taking the time, and I'm sure I'll want to pick your brain on what's going on in this area in the future. So, Evan, thank you again.
thanks so much, Bruce. It's been a pleasure.
All right.